because there was other evidence presented in this case that the external cable connections leading to the defendant's apartment had been altered, we consider the defendant's remaining arguments in the event of a retrial. See also Cater versus Commonwealth, 421, Massachusetts 17, 18, 653, Northeastern 2nd, 576, 1995. If the evidence admitted at the trial was sufficient to send the case to the jury, but it is insufficient to send the case to the jury if all improperly admitted evidence is disregarded, double jeopardy principles nevertheless do not bar a retrial. The defendant contends that the judge erred in denying his motion to enforce a plea agreement. See Commonwealth versus Santiago, 394, Massachusetts 25, 28, 474, Northeastern 2nd, 154, 1985. When a prosecutor enters into a plea bargain agreement, the court will see that due regard is paid to it. There was no error because the defendant failed to establish any such binding agreement on the part of the prosecution. The defendant relied merely and solely on a letter from defense counsel to the cable company for proof of such an agreement. That was insufficient to demonstrate a binding agreement between the defendant and the prosecutor. The defendant argues that his motion for a required finding of not guilty should have been allowed because the Commonwealth failed to prove that the cable company was licensed under CPL 432 and thus was a provider of telecommunication services for that purpose. In order to convict the defendant for a violation, the Commonwealth was required to prove that the defendant, with intent to defraud, obtained or attempted to obtain telecommunication services by installing or tampering with the telecommunication facilities or equipment or by other means. Although telecommunication services are not defined in the statute, specifically provides that telecommunication service shall include the transmission of intelligence by a community antenna television system licensed pursuant to the provisions of Chapter 166A. By virtue of this definition, it excludes from the meaning of telecommunication services a community antenna television system that is not licensed under the provisions of the law. See State Ambulance and Hospital Rental Service, Incorporated, 413, Massachusetts 670, 675, 676. The definition, which declares what a term means, excludes any meaning that is not stated. See also 2A, New Jersey Singer Statutes and Statutory Construction, Section 47.07, 6th edition, 2000. Accordingly, in order to find the defendant guilty of this offense, the Commonwealth had to prove that the cable company in question was licensed under GL Chapter 166A. Although there was no direct evidence that the cable company possessed such a license, two of the employees of the cable company testified about the company's extensive and open operation of cable television within the town of Pepperell. In particular, there was testimony that the cable lines of the company ran from telephone poles in the town into junction boxes that fed cable lines into residences. There was also evidence that the cable company sought the aid of the police in protecting its services from theft, and the police acted upon its request to enforce the provisions of Section 42A. Viewing this evidence in the light most favorable to the Commonwealth, a reasonable juror could infer that the cable company was properly licensed, although no direct evidence that the defendant was registered in a Massachusetts physician's office. How's that?
That's good.
See, that was. $180.
I didn't get it as well as I thought.